Our understanding of burglary has evolved greatly as our society has changed. Some scholars even argue that burglary should no longer be considered a separate criminal offense. Every state has its own rules for burglary, and they vary widely from state to state. In this presentation, we'll analyze the common law elements of burglary, the model penal code's approach to burglary, recent developments to burglary, and a comprehensive example of burglary. The required historical common law elements are 1. A breaking, 2. An entering, 3. Of a dwelling or house, 4. Of another, 5. At night, and 6. With the intent to commit a felony therein. Breaking requires that some force be used to enter the house. Entering requires that part of the burglar's body pass the threshold of the house. Originally, a dwelling or house was limited to the physical home of a person. Next, common law burglary must have been committed at night. Daytime breaking and entering was the lesser crime of trespass. The of another requires that the burglar break into someone else's home, as a person cannot commit burglary in his or her own home. Finally, the burglar must intend to commit a felony once inside the dwelling. This is usually theft, but can also include intent to commit other crimes, such as murder, rape, arson, or assault. Since these definitions were created, states have broadened, eliminated, or modified them extensively. Let's take a look at the Model Penal Code's approach. The Model Penal Code is a series of criminal law rules written by experts in criminal law as a model for how they suggest states enact their own criminal laws. It contains suggested statutory language and comments to help states codify criminal law. The Model Penal Code has been adopted to some extent in some states. The comments of the Model Penal Code indicate that the drafters considered eliminating burglary as a separate offense, because punishing it more severely than trespass and theft was harsh and irrational. The drafters of the code believed that the law concerning the crime attempt, as in attempted theft, now encompassed actions that were traditionally thought of as burglary. However, the drafters believed that burglary was so deeply embodied in American law that it could not easily be discarded. Under the Model Penal Code, the required elements of burglary are 1. A person entering, 2. A building, occupied structure, or separately secured portion thereof of another, and 3. With the purpose of committing a crime therein. These elements apply unless the premises are open to the public, or if the person is licensed to be there. The Model Penal Code's approach to burglary significantly broadened the scope of actions that could be considered burglary. First, the burglary no longer must take place at night. Second, the burglar doesn't have to break anything to get in the house. Third, the crime committed inside does not have to be a felony. The extent to which the Model Penal Code's approach to burglary has been adopted by the states is mixed. Like the code suggests, most states have eliminated the common law elements of at night and the breaking requirement. Also, many states have broadened the definition of occupied structure to include any property owned by the victim. Lastly, many states provide that a burglary occurs if any crime is committed inside a structure. However, states' laws vary on whether they require an entry, if the structure must be a dwelling, and if the dwelling must belong to another. The following example will compare the common law approach to burglary with the Model Penal Code approach. Let's look at the following facts. Ben recently turned his storage unit into a high-tech man cave and wants to show it off to one of his best friends, John. Ben invites John to watch a baseball game in the man cave at noon. When John arrives, Ben opens the storage unit's door and beckons John to enter the man cave. John sits down inside and they watch the game. After the game, Ben asks John to leave, and John does. John makes it to his car, turns around, walks back into the man cave, and grabs 83 cents worth of loose change that was on a side table right at the entrance. He takes the change from in front of Ben and runs away. First, let's look at the common law approach. John could not be convicted of burglary under the common law. John did not break into a dwelling at night, and he did not intend to commit a felony, as stealing less than $1 is a misdemeanor, not a felony. For John to be convicted, the following facts would have had to have been different. First, the man cave must have been in Ben's house. Second, John must break into the house. Third, John must intend to commit a felony, such as assault, and not a misdemeanor, such as petty theft. Fourth, John must have taken these actions at night. Since John did none of these things, he could not be convicted of burglary under the common law. However, John could be convicted of burglary under the Model Penal Code. First, John entered an occupied structure, in this case, Ben's converted storage unit. Second, while John did not have to break into the man cave, he did have to enter uninvited. Once John left, he no longer was an invited guest and could only re-enter the structure as a burglar. Finally, John must have intended to commit a crime in the building or structure. Here, John entered Ben's man cave with the goal of taking 83 cents worth of loose change. Thus, he could be charged with burglary. State approaches to burglary offenses vary, depending on what elements a jurisdiction's statute has adopted. Some steadfastly adopt portions of the common law. Some embrace the Model Penal Code's take on burglary, and others go far beyond either the common law or the Model Penal Code. No matter what elements are needed, the intent of what burglary seeks to prevent remains clear and evident.